is Philip Merrill. I'm a person who's at one time or another has done some legal work in these areas, and I'm here today actually on behalf of Jim Wolfong, who was head of H2O for Maine, and as someone who served here a long time ago, watching your efforts this afternoon, which I might say were tireless, I'm glad that I'm retired. But just to suggest that we have a resource that, because it is in abundance here, we tend to think of it as being something that is abundant everywhere. And because we can get it just by digging into the ground, I have a well on my farm that still provides water today, that somebody dug a hole under the ground about 10 feet, 150 years ago. Because we have water in such abundance here in most parts of Maine, it's easy for us to look at this resource as limitless. But I think that for the very fact, and I don't say this to suggest any sort of conspiracy or any sort of malintent, but the fact that international companies are placing a high value on getting access to this water and establishing this dominion and keeping it ought to at least raise in our minds the question of looking down the road when this water is going to be extremely valuable to deliver in a tanker to California or to the Mideast. Do we have the protections in place that we need to make sure that this resource is going to continue to serve Maine people? The law of absolute dominion means that if you get your well into the ground, you can take out as much as you want. Now, this 17th century common law was based upon this scientific principle. We don't know where the water comes from underneath the ground, and we don't know where it's going, so we're going to say whatever you got underneath the ground is yours. So we know that when we're talking about this resource that we're allowing people to pump out of the ground, that it really isn't a resource that's strictly on our land, the way a tree is on our land, or a rock is on our land, or even minerals are on our land. It is more like the air, or more like the surface water. It is passing by our land. That is why most jurisdictions have adopted a different concept than the law of absolute dominion, which is essentially the same concept as we have for our surface water, which is a concept that says we can continue to use the water, in the case of surface water that abuts our land, or in the case of groundwater that's underneath our land, that we can use it and put it to use. It's just that our right to use it is subject to not unreasonably affecting the property rights of somebody else to use it. Now, that is the essential difference between Maine's law and New Hampshire's law. And it's the difference that would be addressed by making this change, because it is never the concept that we've had with regards to our surface water. But by and large, the uses that people are making of the water now are not unreasonably affecting the uses that others can make of the water, if you'll allow me to use the expression downstream in talking about groundwater. In the city where I used to serve when I was a state senator here, the city of Portland, it's served by a lake. And the water district has taken water out of that lake for a long time under these common this common sense of reasonable use, and it hasn't affected the water district at all. As a matter of fact, I would argue it protects the water district in terms of others if they did something that would tamper with it. So what Jim's thinking is that by bringing this body of law that we're familiar with, which essentially is similar to the law in New Hampshire, it would be easier for people to understand what this concept of reasonable use would mean, essentially by adopting the reasonable use standard we already have for surface water. Let me underline a point here too. You might say to yourself, why haven't the courts adopted this reasonable use standard? The old one sounds kind of arcane. It's obviously based on silly science. Why haven't the courts done it? Well, you might be interested to know. The reason the courts haven't done it is because you didn't do it. There was a recommendation to this legislature from a commission that the legislature established, I think about a decade and a half ago. There was a recommendation to the legislature that they ought to adopt the reasonable use standard. And the legislature didn't. And I don't know exactly why they didn't at the time, but they did not. And when the issue was brought to the Maine Supreme Court in essence said, whatever the merits of the reasonable use standard, it seems that the legislature has made a decision. Now, as somebody who served in the legislature, I always took issue with the fact that when the legislature didn't do something, it necessarily represented the decision. Sometimes when we did something, it was hard to know exactly what decision we had made. But nonetheless, that was, as those of you lawyers know, the Maine courts have been traditionally very careful in this regard. For years and years and years, they left tort protection laws alone because they deemed that the legislature had made a conscious decision in not changing it. So anyway, that's the reason we're left with not a reasonable use standard, is because the court has deemed that the legislature failed to act. If you go to Freiburg, Maine, and you stand next to Lovewell Pond, and walk back from the pond maybe 50 feet along a tributary that comes into the pond, you'll see a Nestle pump, or it's actually not owned by Nestle, but they buy the water that's pumped out of it, that goes down into the ground about 50 feet right there in that gravel subsurface where the water is flowing into the pond. That water that's beneath that pump, that's taken out by that pipe, is treated under one set of laws, absolute dominion. If you took that pipe, pulled it out of the ground, and slid it along the ground out into the lake, it would be dealt by a different law. Now, does anybody honestly think that that's all gravel up there, that the water that's moving through that gravel doesn't move in and out of that pond? Of course it does. Of course it does. Now, I'm not saying that the water they're removing now has or has not had an effect on the pond, but it's clearly part of the same system, and I would argue that logically should be treated and valued the same way. When Jim brought a piece of legislation and this committee got Jim and the H2O for Maine together with Nestle's and others and looked at a lot of these requirements that are necessary when a major well is put in, and that was contemporaneous with trying to work out the water transport law so that it
I'm talking
so
about
that it
new
made
rights.
sense. I'm trying to say that there is already some limits in terms of this issue that are already in the law. That's all I was trying to say. Okay. Go back and ask your question, because I've left you.
My question was, does this now give, you've spoken, most of your discussion here has been framed around landowner, at least in response to my question, landowner rights.
Mm-hmm.
And my question, based on one of your answers
yes.
recently, as to whether this also gives rights that do not now exist to non-landowners.
Well, maybe to an extent that they don't now exist. Let me answer that question. For example, if you removed the groundwater, to the extent that it affected, let's say, surface vegetation, or affected wetlands, or affected the temperature or water quality in a lake. And we all know that the coldest place in a lake is where spring water is coming up somewhere in the bottom. I used to fish the Sebago Lake a lot, and we looked for where the deep springs were. To the extent that it affected that in a negative way, and the public has an interest in those things, yes. Now, the only reason I'm being somewhat equivocal about that is we have some of those protections already in place. See what I'm saying? So it's not black and white. It's not, we don't have anything now. Right now, today, if Nestle's drained so much water, say, for example, out of an aquifer up there that it dried up a wetland, the public could have an interest in that right now, I think.